So this topic that we have decided to talk about is art of arguments, mastering the craft strategies for persuasive and effective arguments. Now, this topic is very interesting because persuasion is something that when we are born is when we learn the art of persuasion. A child, when it cries, asking the mother to give the child milk is an art of persuasion. So this is something that we learn right from the time we learn to communicate in whatever possible manner. When we talk to our friends, we try and persuade them. When we talk to our teachers, when we talk to our parents, when we talk to our siblings, I think persuasion is one art which we learn from the time we have learned about communication. So it is an inherent art in all human beings. But when you bring this art to law students, it takes a particular structure, it takes a particular character, and it takes a particular form. Now, when we are studying in law schools, there are no separate classes on the art of arguments. How we learn arguments in a school of law is by way of attending the moot courts, doing our internships and watching the senior counsels argue, and generally inculcate the concept of arguments through our understanding of the circumstances and surroundings. So in this very intricate realm of law, it is very important, or rather, most important, is to construct a compelling legal argument where we are able to persuade the person who is in front of us. Most times they're not as the judge. And this art of arguments, it plays a very pivotal role in shaping the outcomes on behalf of our clients in any legal proceeding. So it is very important to understand the basic fundamentals of the art of argumentation, and that is to have logic in the arguments, to have a basic preparation in the arguments, and to have a most important understanding of law. And then comes the rest of the posturing, which we call, the body language, the art of assertion, the art of arguments, the art of persuasion, in whatever nomenclature that you may call it. Now let us look at the next slide. Can the slide move, please? Yeah. So importance of effective legal arguments are persuasion, which is not just about facts, but also about understanding the logic behind arguments and the legal reasoning with an effective communication. The mode of communication can be any, but what is more important is the effectiveness of that communication. And the other important aspect is a well-crafted judge argument, which can influence the interpretation of the law and shape the judicial outcomes in favor of the lawyer who is arguing the matter. So if you look at the basic skills, it is most important to understand that legal proceedings are about, one part of it is about handling the paper book, and the second part about it is about understanding the law, and the third part is about the art of communication. When you merge all these three together is when you learn the art of arguments. When you talk about the paper book, the basic foundation for any art of argument or advocacy for that matter, it entails you to have a structured compilation of all the critical documents which are necessary for the court proceedings. In fact, with experience, what has happened now is that we can actually gauge the quality of the lawyer with the manner in which he has managed or maintained his file, the number of flags, and the note, the way in which the note is made. It makes a lot of difference. The other element is, the key components rather, is the pleadings, the WS, rejoinders, order sheets. I think all of this, the manner in which it is maintained, makes for an efficient lawyer. And the third is the quick or the swift reference, where you have the facts and arguments in place. These are basic foundations. The other important aspect is to understand or master the art of handling the paperbook. The documents are arranged in order, the order sheets are arranged in order, the communications are arranged in order, and you have properly indexed and flagged the crucial documents, which is easily identifiable through tabs in today's time when we are looking at the documents in soft. We have life has become much more easier. We are able to access the documents within seconds. So I think it is very important to have the master of sequence. What is the most important? What is less important? And what is the least important? And in that sequence, if the files are managed, makes a lot of difference in terms of being able to handle the files. And in terms of the documentation, what is important is these that are mentioned, the procedural history of the matter, the complete records, orders, correspondences, notices, affidavits, evidences, if they are managed and maintained in a proper manner, it really helps the lawyers be prepared to argue the matter in a best manner possible. The other element which is important is to understand the courtroom dynamics. So what I used to, and even now, and I think I've heard it from many other lawyers as well, is when I have to go to a court to argue the matter, I usually try and sit in the courtroom to observe the judge, the manner in which he's conducting the matter, what are the things that are most important for him, what is his thought process or her thought process in which they are approaching the matter or matters. So each judge have their own distinct approach to handle arguments. Some are very interactive and they are very communicative, so they are asking questions from you. There are some who are more passive listeners and would only be looking at you, observing everything, absorbing everything, and not having so much communication or a dialogue one-to-one with us. Then, so this is a very important understanding that we need to develop. The second important understanding is to also understand their thought processes. How are they thinking? What are they thinking? How would they want to understand the matter? So I think it is very important for us to understand the courtroom dynamics in that sense. The other important element that we need to understand is the key to understanding the bench is to read their judgments. How have they been, interpreting on a particular issue? So if we are able to identify that, I think it makes our life much more easier to present the similar kind of judgments before the bench. Or generally also, if we are able to observe the courtroom demeanor, that also makes a lot of difference in terms of how would I want to structure my arguments. And the third is to understand the legal philosophy, where there are some judges who want to do a very strict textual discussion. There are some who are very purposive interpreter, or there are some who are very pragmatic decision maker. So I remember, in fact, and there are many such instances from the past 24, 25 years that I've been practicing. And I have noticed that each judge expresses a lot through their body language. So whether they are open to your arguments, whether they are following your arguments, or they are disinterested in your arguments, you can make it out completely through the body language and the gesture. So that is something which is important. And how do we get that? Is only when we observe the bench. The other element is engaging the judge, or engaging with the judge rather. And how do we engage is when you are able to bring the judges to the point that you are trying to make. If there is a communication either through their body language, through their eyes, or through their words of the questions which are being asked, then I think the honorable judges engaged in the discussion. If they are not interested in what they are what is being argued, then they would not have the same amount of communication in any manner possible. So I remember when we used to watch Mr. Arun Jaitley argue, and there was one matter where he was leading us in a matter. He did not open the file and went on with a fluency of speech for the 15 minutes, the first 15 minutes that he engaged with the honorable judge, he did not open the file. There was no need for the bench also to open the file. And once he had reached the point where he had made up his, his entire argument, is when he opened one order, showed it to the bench, and got the order that he wanted. So I realized the art of communication is so important. How you express yourself becomes so much more important. So it is very important to, ensure that you have the ability to be able to engage with the judges. The other very important point that is mentioned is compelling the bench to follow what is being argued in either by way of looking at the file or by understanding what is being argued. But it is very important to navigate through your processes to be able to take the honorable bench to what you are trying to substantiate. And then when you are looking at the specific pages in the case file to make the judge open your file and go through the intricacies of the case, I think half your job is done. Thereafter, a lot of it also depends on the merits of the matter. And there are so many other circumstances which play a very crucial role. But that is very important, is that you are able to ensure that the judge is able to refer to the same page and para numbers as you are. So I think this is the crux. How do you get prepared for an argument? One is master every argument. If you have, say, 20 points that you have taken in the grounds, identify the key grounds that are to be taken. Identify those key grounds, 5 or 6 of them, have sufficient judgments and not too many on the same point. I think it does not really make sense to have 15 judgments on the same point. 1 or 2 judgments, which actually are most important, if you are able to focus on that, is sufficient for the bench to understand what you are trying to say. The third is master your facts. There can never be a substitute to a complete understanding of the facts. How much of those facts are necessary to be argued is something that you have to take a judgment call on. But to understand the facts is the foundation of the arguments that you have to make. The other important aspect is, of course, knowing the judgments. But the most important element here is think like your opponent. If you are the counsel, and this we do very regularly during our preparation, is you are the lawyer for the other side. And if you have to argue this case, take the best arguments possible from your end so that we are then prepared to at least have a pushback on those arguments that are being taken by the opponents. So it is very important to be prepared for the rebuttals in advance when making the arguments. Think through all possible kind of questions that may either be raised by the bench or by the opposite side, and be prepared in that manner. Then comes the structuring of your arguments and the art of sequencing, how and what is important. So as I mentioned and gave the example of Mr. Arun Jaitley, there are so many other senior lawyers who have actually, helped me shape the art of arguments. And I would see, like the likes of Mr. Harish Salve, who would come straight to the point and would make such a compelling point, because in Supreme Court, you get such little time and you have to, get the attention of the judge in that little time. So he would make a very compelling point of 3 lines before the bench, which will, make the judges look forward to what is being now said. So what is it that has actually happened? So to get the attention of the bench is very important in the first few lines. So your introduction has to be brief, your introduction has to be focused, and your introduction has to be oriented towards the relief that you are seeking. Then after the relief that you have sought and you have taken the attention of the bench, comes the statement of facts, where you talk about what exactly is the facts that you have. So that becomes very, very critical. And those facts should also be very crisp. So if the facts go on for the last 30 years, you have to bring those facts of 30 years into, say, not more than 10 or 15 lines. Because in most cases, the benches have very little time and you have a lot more to say. So once you have been able to again state the facts, and if you are seeing that the bench is more engaging with you, is when you start going into the other facts as well, which are relevant and which are required for advancing your argument. Then comes the legal issues. So what are the key considerations or points of considerations for the bench? Or in cases where the issues have already been framed, then in that case to identify those issues and then to address each of those issues meticulously. Focus on addressing those issues until the time you have been able to satisfy yourself. And, usually when you have been able to satisfy yourself, you are also able to satisfy the judge or the arbitrator as well. So try and argue in a methodical manner, giving the brief facts, then the detailed facts, and then the case laws in that regard, the precedents in that regard, and then sum it up. So conclude each of your arguments in that manner. So in case there are 4 points of consideration, each 4 points of consideration should have been thought through properly, structured properly, and argued properly with the proper conclusion for each of that. The next important art is the mastering the core and ancillary arguments. As I mentioned earlier as well, you have to identify your 5 or 6 core issues or the key grounds. So first of all, focus on those primary arguments because they are the ones who are going to give you the immediate relief that you're looking for. They are like your heart and soul of the case. So read all the cases that are supporting your primary arguments. Then are your backup arguments, because if you have taken 15 grounds, 5 are your key grounds. There are 7 or 8 which are your secondary arguments. In case those 5 are not able to satisfy or impress the bench, then the backup points, which also aid and assist in reinforcing the earlier points or 5 or 6 points. So that only extends your arguments further, because that helps you in terms of building the case in that manner. And then after the ancillary arguments are the other arguments. So the balance, which is the left out issues, which you have to also try and argue. So you have to think like a skilled strategist in that sense and be able to strategize on how should you present your case in that manner with good oration. So these two are very important. Strategy and oration are also very important in terms of being able to unravel the entire concept that you are trying to propagate before the bench. Then this slide actually talks about refining yourself. We talked about it, identifying the core, ancillary, and other arguments. Not all the points have the equal weight, so we have to distinguish between the two. We have to also ensure clarity and precision in what is being argued. Most times we actually get lost in the legalese and convoluted reasonings, and which actually, trust me, more often than not, the judges are not interested in your knowledge of legalese or those convoluted reasonings. So focus on keeping things simple. I think it always helps to keep things as simple as possible for anybody to read, understand, and appreciate what is being said. So it does not require very complicated English. It only requires a very simple and logical arguments. So because the judges may not be familiar with the facts of the case or the details of the case. So if you make it very complicated, it becomes very difficult to understand. And especially if you are dealing with, say, a property matter which has multiple stakeholders and multiple issues at different levels, it becomes even more important to keep things simple and lucid and flowing in that sense, so that it can be structured in a certain manner and not jump around haphazardly from one fact to another. That makes a lot of difference. Now, the other important aspect also is about the body language. We touched upon it earlier also, that body language plays a very important role. The judges are experienced. They have been lawyers in the past. They have sufficient experience. They look at a person and know whether the person has merit in their case or not. So how confident you appear before the bench? What is your demeanor? And your demeanor and confidence should not reflect in any manner any kind of attitude or ego. So keeping your humility on, but confidence is very important. Your voice has to be firm, and you would notice that most arguing lawyers have a very firm voice. So because it is very important to communicate in a firm manner with sufficient clarity in your language and in your expression. So and especially because what happens is that persuasion in general is it is a capacity to change the view of a person who's trying to understand your facts, or of somebody who's trying to understand your matter in a certain in a certain expression. So you have to change the belief, you have to change the attitude, you have to change the thought process as well. And therefore, till the time you have the complete clarity in terms of your facts, and in terms of your law, and in terms of your manner of presentation, sometimes that is where the gap happens. The other element aspect is the basic courtesy. I think in today's time, and I see that more often than not that is happening, is we are forgetting the basic courtesies and professionalisms when we are addressing the bench. The traditional way of addressing the judges as your lordship and honorable court is something which has been in a matter which has been going on in the past, but there are many judges who have also, in fact, suggested that they should be addressed as madam or sir, and they are not looking at your lordships or my lordships as a general way of addressing. But what is more important is to come across as an honest and sincere lawyer who's there to honestly fight on behalf of the client, who's not trying to misrepresent the facts or state incorrect facts. Because trust me, the credibility, once it is lost forever. And therefore, it is very important to ensure that you are honest in your representation of facts, representation of law. Do not try to misguide the judge, because judges have much, much more experience. And therefore, they can actually know from the manner in which it is being said. And most of them also read the files and come. So if we try to misrepresent the facts, that would actually come back to us, and in a very harsh way. The other important aspect is to have civility towards the peers. Even if it is the lawyer for the opposite side, it is very important to ensure that we maintain a certain decorum, irrespective of how heated the arguments are. That decorum should never be lost in any manner possible. And the other, I think it is most important, is to always be prepared for your matter when you go before the court, irrespective of whether you have a final argument or not. Never ever go to the court without reading the file thoroughly, and arrive in court on time, because punctuality is something which is a basic expectation from a lawyer. So those who are not punctual are not looked upon also as sincere and serious. We have discussed about it, of how should we sequence the planning of arguments. I think we have discussed structuring the arguments logically using charts, diagrams, flow charts for clarity. In fact, in one of the matters, and I give this example quite often within office as well, is when there was a very complicated matter which went up to Supreme Court. So it had its journey covered. And so there were a lot of facts which were covered. We went to a senior counsel. It was Mr. Ashok Desai at that point of time. He took 45 minutes to understand the matter, and another 45 minutes to get a small diagram made, which was one-pager diagram. And that is what was presented before the Supreme Court. And it took 30 seconds for the benches to understand what has happened in the matter. So a matter which had gone from the district court up to Supreme Court took 30 seconds for the bench to understand what has really happened, and then to be able to persuade the bench to get an interim order in our favor. So that was the art of the senior counsel, where he was able to present the matter in the simplest possible way by way of a diagram or flow chart. The other important aspect is the sequence of matters, because building the momentum from the foundational point, how it has started to where it has reached, it is very important to follow that sequence. and then provide the supplements through the supporting documents, through supporting judgments in that regard. So the sequence becomes very critical in that sense. The other important aspect also is that, we need to understand that argumentation is also an art to exchange, or also an art to evaluate or diverge the opposite viewpoints. So what is important is to ensure a logical reasoning in whatever is being argued, with an evidence to support whatever is being argued. So it is very important for us to ensure that it becomes easy for the judge to be able to navigate through the file in a structured manner, guide the judge efficiently in terms of navigating through the documents, and then present the supporting documents concisely, rather than wasting too much time in flipping through the documents because you have not prepared yourself well with the supporting documents. So it is very important to go through each and every aspect of the matter as thoroughly as possible. Then the important aspect is, and I also mentioned this earlier, is to have a concluding remark, which is the final impression, where it is the entire storytelling that you have done thus far has to be summarized for that story to remain in the minds of the judge when the judgment is to be dictated. So it is very important to have a compelling and a cohesive narrative, so that it is easy for the bench to understand, appreciate, and then pass order in favor of the lawyer. So it is very important in that sense also to have a very confident closing, where you are able to reinforce on the relief sought, why and how and when and what. All of this addressed in your concluding remarks. So this is the basic art that was important to be understood. And I really wish all of you the very best. Very important is to ensure that we use the language which is simple. We also use the body language, which is not complicated. We don't give wrong signals. Our non-verbal communication is as important as our verbal communication. We have to be very clear. We have to be very precise. Our hand gestures and body movements, our facial expressions, our voice projections, it can have a different impact on the legal argument. And therefore, it is very important to understand how to present our matter in an efficient and effective manner. And also there are, sometimes we have seen many counsels also doing this, is to repeat and reinforce the arguments. They would come back to the points which are very critical for them. Even after they have moved forward, they would come back, repeat, reinforce, and then move forward. So it is very important to have an understanding of some of these very important aspects. And the other element that I've repeatedly been stating is the effective use of precedents. So the bottom line is that persuasive style of advocacy, it lies on or hinges on the basic foundation of legal knowledge, with a mastery in terms of the facts of the case, and a mastery in terms of the judgments or precedents in this regard, and a proper preparation in that regard, with a certain amount of clarity in terms of your oration, a certain style of body language, and a certain style of focusing on understanding the manner in which the judge wants to hear the matter. I think that is how I would want to summarize this session. Thank you so much, and wishing you all the very best. Thank you.